Supplementary fresh admission item number 1.
My lord, in this case, I am for the petitioner, my lord. As per your lordship's order, that is dated 14/11/2022, which I have annexed as Annex 2 of my writ petition, as 26. I approached the collector to, by way of miscase, to stop the construction which is illegally going on the land of Jagannath Mahaprabhu Vijay Puri and the government land. In this connection,
Mr. Parida, please address us on 15/2/2023 order. Last occasion, an order was passed, so you are supposed to reply.
Milord, I filed one affidavit, Milord. I filed one affidavit.
Yes.
Yes, Milord. In pursuance of that affidavit, after filing of affidavit on last Friday, that is on 24th to 2023, the collector taken up this matter. But in that date, no interim order has been passed, Milord. And now the opposite parties are continuing the construction work.
You take instructions. An additional affidavit has been filed.
No, affidavit copy has not been served on.
Yes, I served, Milord. I served copy. Milord.
You have not served. It is not there in the files. You serve
Yes,
another.
again, I will file another copy. I will give you another copy.
An additional affidavit dated 21st February 2023 has been filed by the petitioner, in which he states that he has been unable to get a copy of the order dated 6 January 2023, passed by the collector, in this case number 60 of 2022, and is therefore unable to inform the court of the next date of the proceedings. Full stop. He adds that in the absence of any interim order, the opposite party are continuing with the construction on the land in question. Paragraph, Mr. D.K. Manti, Learned AGA, will be served, states that he does not have a copy of the said affidavit. Mr. Parida undertakes to serve a copy on him today itself to enable him to take instructions. List on. Ninth March.
My lord, I am for the OP number 2 and 3. Let the copy of the affidavit be served on me also.
Or
Item number 2.
Me, please, Milos. Milos, this is a writ petition, Milos, challenging. Milos, am I audible, Milos?
yes.
Milos, this is a writ petition, Milos, challenging the action of the department, Milos, where on one hand, they have kept my appeal pending reserved for orders, Milos, for 1.5 years. On the other hand, they are pressing for demands. Your lordships, in identical scenario, my lords, your lordships have passed.
Appeal is pending for the National Faceless Appeal Center, my lord.
Your lordships knows
that is pending. My lord,
in AFC, my lords, we are supposed to file our written submissions. We can't. There is no hearing, and written submissions have been filed since July 2021. Still, then they are keeping it pending on.
No, appeal, your lordship may direct for disposal of the appeal. My lord, in the meantime, but demand has been made of 10% against the order of stay, my lord. That has been undertaken by him, and some amount has already been deposited by him. But he is enjoying the interim model. Page 302, lordship kindly see page 302, annexure 23. That is the raised amount against the demand. My lord, that has been segregated to different phases, my lord, and that has been liberally considered. He may deposit on that.
And why are you keeping the appeal pending? I've never heard of CIT appeals not passing an order for 1 year.
That is now pending for the National Faceless Appeal Center. Lordship may direct for disposal of that appeal. In the meantime, he has to comply that order against him. He has already undertaken, and he has paid some amount.
What is this? You already undertaken to pay?
Page 302, Lordship kindly see, he has paid some amount out of 37 lakhs, my lord. He has already paid a sum of rupees 2 lakh.
No. What's the total demand, sir?
Total demand is 2 crore 1 lakh 22,000 and some odd.
All right.
Lots,
So he had undertaken to pay 37,72,000.
Yes, ma'am.
What has he paid so far?
He has already paid. Lordship kindly see paragraph 4. That is 2,51,600. He has already paid.
Milords, there is no this is the order that I'm this is the order that I'm against. I'm not undertaken, Milords.
Yes, that is undertaken page 137.
In identical scenario, there was a similar incident that occurred. Your Lordship will see that order of your Lordships, where your Lordship will see the order of 4th January 22. May I read that order, Milords? Para 3, till the next day of hearing, no coercive steps shall be taken. It is clarified. This, however, will not prevent the appellate authority to expeditiously dispose of the appeal stated to be pending before it in accordance with law. Then, Milords, the 10th of August order, having heard learned counsel and considering that the prayer is a limited one, the court directs that the appeal filed by the petitioner be disposed of by the NFSC within a period of 4 months from the date of...
But we don't know whether in that case, whether the similar order like this was passed.
Yes, Milords. There also there was a demand. There was a demand.
Yeah, but you had filed an application. Here you seem to have filed an application for stay of the demand, on which this order has been passed on 6th February.
Yes, Milords.
Asking you to pay 20%.
Milords, that is what I'm saying. Milords, since July 2021, I have finished my responsibility in the appeal. In 2023, they're asking us to pay the amount instead of disposing the appeal.
No. You seem to have filed a petition on 3rd October. Just let's come to page 302.
Yes, Milords. 3rd October 22. But Milords, my written submissions have been filed since Milords 24th of July 2021. Your Lordship will see 217. Page
No, but what was the occasion for you to file this petition on 3rd October? What was that?
Because Milords, they are asking for recovery of the amount when they themselves are keeping the...
Where is that letter asking you to...
Yes, Milords.
Seeking recovery. Where is that letter?
Yes, Milords. We'll see at page 285.
You seem to be filing petitions after petition. There is a 24th June, you again prayed for stay.
Yes, that is before the...
That is not that is Milords, a reply to the arrear demand, where I say that I express my difficulty, but Milords will take a view of the fact that my responsibility in the appeal has been over since July 2021. After that, I cannot do anything else than wait for the order.
Before the appellate authority, my lord, he has not, before the income tax, my lord, Commissioner of Appeal, he has not filed any application for stay. He rather filed application for stay before.
Have you taken any instruction that since 2021 he has been filing written statement before the appellate authority, and he is not disposing it of...
He should seek stay before the appellate authority, my lord. Instead of that, he filed application before the principal commissioner of income.
Don't you find it strange that since July 2021, an order is not being passed in an appeal?
That is, my lord, that is to be passed.
No, don't you find it strange? He find it strange. I don't know whether you find it strange.
My lord, he filed application for not to take any
so you don't want to answer the question, basically.
My lord.
You come to date sheet, appendix 2.
My lord.
10/1/2021. 20.
Yes, ma'am.
Appeal was filed.
Appeal filed.
Thereafter,
Milords will see notice.
petitioner in compliance to notice.
No. So this 10th March, no, Mr. Acharya, 13th March, that stay application was allowed subject to your depositing 10%, correct?
That is, my lord, before the income tax officer.
1 minute, sir.
Sorry,
I'm talking to him. When I ask you a question, you don't answer the question. Sorry. So I'm forced to ask him, sir.
Sorry.
There is an order passed on 13th March,
My lords,
requiring you to pay 10%.
Yes, my lords.
Have you complied with that order?
My lords will observe the date of the order. It is just before the COVID period. During
Whatever,
COVID,
sir. My question to you is, have you paid this 10% or not?
no, I have not paid that 10%.
Where's the
admittedly.
question now of getting further stay then?
No, all I am
At your instance, an order has been passed granting you relief, saying if you pay 10% is more than enough. You don't comply with that order.
No, my lords, 10%, I don't admit to that 10%. What I'm saying, my lords, is there was a COVID period that intervened because, my lords, after 10 days, my lords, there was a lockdown in the entire country. That thereafter, my lords, the income tax department itself gave the liberty of not recovering for demands. My lords, in the meanwhile, I completed the appeal hearings. I completed whatever was my responsibility in the appeal.
There's no question of responsibility. The appeal, sir, it is your appeal. During the pendency of the appeal, you asked for and got an order of stay.
Very well, ma'am.
Correct. That there's no question of a moratorium for non-compliance with such order.
No.
The COVID period and orders passed by the Supreme Court was only that little extent limitation.
No, there was.
Suppose you had to comply with an order on 13th March. The Supreme Court orders don't say, oh, you did not comply for the next 2 years. That's not what the Supreme Court says.
Well, Supreme Court, that is an order on limitation. Plus, there was Income Tax Department's own circular, which said that they will be not recovering for demands in view of the situation that was prevailing. There was an income tax for which they were not recovering. That was
so that according to that circular has continued indefinitely now.
No, Millards,
no. Just we need to understand, sir. What is your argument? We need to understand. What are you trying to say? You don't have to comply with that order at all. 13th March hereafter.
Yes, Millards. Only thing I have to comply. I bow down to that. But
you comply with it and then ask for orders from us. All right.
Millards, only thing that if I may submit, Millards, is that your lordship will take a Millards, if your lordship will direct that everything is over within a month's time if they dispose of the appeal till that date.
That's a very, very good way of putting things, sir. That ask them to comply with something. Don't ask me to comply with anything. This is a very good way of arguing, but it's difficult for us to accept.
In that event, Millards, only thing, if I may pray, Millards, your lordships, this person, Millards, is an old lady. So
whatever, sir. 13th March, this old lady got an order in her favor. Right? There is no provision in the Income Tax Act, unfortunately, or the Constitution of India that says old ladies do not have to comply with orders.
No, that's not.
So let's now come down to hard law. You applied, you got a stay in your favor, you have to comply with that conditional stay order.
Yes, Millards.
Don't, whether you're old lady, young lady, no issues. You have to comply.
Millards, if I may pray, Millards, instead of 10%, Millards, if you
No, now it's too late, sir. 3 years later to come and say now that 10% order, you better modify. And that is, I'm not sure, it's not even your prayer in the
10% that to 8 installments. You yourself have written that 2,51,000 it comes.
Millards.
Way back in 4 years ago. Right. Almost 4 years.
Actually, it also points to the inefficiency of the department.
Millards, I'm completely in your lordship's hands. Your lordships can just direct, if your lordship, I'll make some deposit, Millards. The returned income, Millards, was 1.79 lakhs. Returned income was 1.79 lakhs.
Mr. Acharya, I know what is going to happen now. I'll start dictating the order and will say, sir, I want to withdraw this writ petition.
Millards,
it's going to happen in the next 5 seconds. I'm going to start dictating the order now.
Your lordships, in that event, lordships may kindly allow me to get some instructions from the client insofar if they can make some deposit. No. Because Millards, what is required today is that appeal, Millards, has to be disposed of. That
it has to. But this is separate. That is separate. All right.
Yes,
the petitioner has approached this court. The petitioner has approached this court seeking quashing of a letter dated 6th February 2023 issued by the
Millards, against that 6th February
Principal Commissioner of Income Tax, Sambalpur, requiring the petitioner to pay the remaining installments in compliance with the conditional order of stay passed during the pendency of the petitioner's first appeal before the Commissioner of Income Tax Bracket Appeals in respect of assessment proceedings pertaining to assessment year 2012-13. Paragraph. It appears that on 13th March 2020, a conditional stay order was passed requiring the petitioner to deposit 10% of the demanded amount in 8 equal installments. Paragraph. Contending that the COVID period had commenced soon thereafter, and therefore there was a moratorium on enforcement of demands of the department, the petitioner did not comply with that conditional stay order. Paragraph. Today, an argument is made by Mr. Acharya that since the final hearing in the first appeal before the CIT bracket A concluded way back in July 2021, a direction should be issued to the National Faceless Assessment Center, bracket NFAC, before said appeal is stated to be now pending, to expeditiously dispose of the said appeal without requiring the petitioner to comply with the above conditional stay order. Full stop. The above submission is not acceptable to this court. Full stop. The petitioner, having sought and obtained in her favor a conditional stay order, is obliged to comply with that order before requiring a direction to the department to complete the to dispose of the appeal stated to be pending. Paragraph. Consequently, the court is not inclined to grant the relief prayed for. Full stop. This order will nevertheless not prevent the department, bracket NFAC, from disposing of the pending appeal as expeditiously as possible. The writ petition is disposed of with the above observations. All right.
That's the only thing your lordship dictated. NFAC is Faceless Appeals Assessment Center. It is Appeal Center.
All right. All right, sir.
Item number 3.
Okay.
Obliged. May it please your lordships. Well, as the return filed for the assessment year 8-9 was scrutinized, a scrutiny assessment order was passed, demand was raised, it ended in the appeal by the second appellate authority, that is the tribunal, Annexer 1, which went in my favor. Annexer 2, page 21, my lords. Thereafter, my lords, the assessment year 8-9, a reassessment proceeding after 4 years was initiated.
147.
Without recording his satisfaction that the assessee has failed to disclose truly and fully all materials. Your lordship have rendered the judgment in Olinas truly. I am not there, my lords. Thereafter, my lords, I went and filed an appeal. Lordship will see Annexer 5 at page 44. And the proper page, I take your lordship only to observation of the learned CIT appeal, who has said, lordship may see page 49. I have carefully perused the facts of the case and have examined the original assessment order passed for the assessment 8-9 under section 143.3 dated 3/12/2010 and also the order under section 143.3 for the assessment at 8-9 dated 31st of March 2016. The detailed submission of the assessee have also been examined. Now the exercise of the reopening of the reassessment proceeding of the assessee suffers from several fatal shortcomings which are analyzed hereunder. Thereafter, my lords, lordship will turn to the next page. Again, it is first. Again is
so. ITAT sends all these appeals back to the CITA.
No.
The A was not heard.
Yes. Now, my lords, what the tribunal did. Tribunal on a very technical.
Yeah, that A was not heard. Send it back.
But it is not a duty of the assessee to go and serve the notice in ITNS form 851.
That's all right.
It is the office of the CIT appeal. Now, what happens, my lords? The OP number 2 assumes the power of the CIT appeal and issues the intimation under Annexure 1, then automatically the demands have revived. How can he do? How can he do when the said power is only for set off? You are not the appellate authority. You are only to intimate whether any set off is done, whether any refund is to be given to the assessee or not, or the department will get the refund. Now, how can he issue mallards?
No, 1 minute. When you went before the CITA, was there an interim order in your favor?
Yes, my interim order was by the High Court.
Where is that?
Yes, mallards. That is their mallards.
That automatically revives, sir. Once this appeal is restored, the interim order also revives.
Yes, that is the thing, mallards.
All right, show us that, sir.
Yeah, page 4, Annexure 4, page 40.
All right. So all we have to clarify is that interim order revives.
Yes.
All right. Who's for the department?
Mr. Satpathy mallards.
It's as simple as that, sir. Once you restore an appeal, the interim order gets restored.
This is clearly intimation, Lord. Your Lordship, see what is the section says, Lord. He has to reply against the intimation, Lord. He has to reply. Lord,
Now you're getting really technical.
No, not technical. Here it is CPC has issued the notice, Lord. As your Lordship know, now there is a demand. Let me complete, sir.
You complete. You have already completed issuing the
All right.
Yes.
All right. Tell us.
Lord, intimation is issued by CPC, Lord. It is an intimation. And CPC is based on the demand, Lord. He has issued the notice, Lord. And after, Lord, tribunal has set aside the matter, the automatic assessment order, the demand is there. Whether he has filed in, whether stay is there. Lord, I understand, Lord. Just High Court order is there.
How can you ignore the High Court order?
No, I'm not saying that I have ignored. I am requesting.
You have mechanically, just what has happened is you have mechanically raised a demand.
Yes.
Saying that now you have to pay without realizing that earlier there was a stay granted.
That order, Lord. Therefore, Lord, I am requesting your Lordship that your Lordship may directly use file and reply before the authority by explaining all this. He has passed the order. It is an intimation. It is not demand. Your Lordship, see the section itself. 245, your Lordship, see.
You cannot frustrate the order of the honorable.
It's not a question of
Yes.
1 minute. It is not a question of the order.
You have frustrated. Section 245. Does it require any reply? Section 245 is an intimation.
Mr. Rai, let him.
May place 245.
Yes.
The set-off of refund against tax remaining payable. That is the head of the.
Yes.
Where under any provision of the Act, a refund is found to be due any person, the assessing officer, deputy commissioner, chief commissioner, as the case may be.
How does this provision apply? First of
yes,
all,
Lord. In lieu of the payment of set-up amount, refund part amount.
How does this provision apply, sir?
The person who may refund giving an intimation writing such person action proposed to be taken under this section. It's proposed, Lord. It does not know nothing else taken.
Why does this section apply at all? I'm not able to understand. How does this section apply?
Exactly, my lord. This section doesn't apply.
Mr. Right, please. Now you have to restrain yourself. Yes. This man is already in trouble and you're adding to his trouble.
Let me see. Once the tribunal is remand back the order, automatically the assessment order stands. Demand. But now the question is, stay has been granted. Yes, Lord. Stay has been granted by the Honorable Court, Lord. And that is there.
Mr. Satpathy, I think you're going ahead of. First, let me understand why this section 245 applies. Which is this refund? Who's asking for refund? No, I'm not able to understand. What is this?
It is a intimation as basis on the
No, section 245. How does it apply?
It is refund set up. Everything is there. Refund and set up. Your Lordship, see this refund and set up of the demand. Your Lordship, may I place again, Lord?
Where is it, sir? Here there's simply a demand raised. Where is the question of set off?
And page 20, my lord. He says that you pay this amount.
But where is the question of a set off also here? How does section 245 apply? You explain to me.
Yes, Milord. 245, Milord. When there is a Milord, any demand is there or any refund is claiming the.
No, when demand, this doesn't use the word demand at all, sir. Unless I've got some temporary blindness there. No, I'm just saying it could be that I have got some temporary blindness. You're able to read a word which I'm not able to read. I'm not able to find a word called demand.
No, there is not set up, my lord. Set up of
What are you setting off against what? How is the section applicable?
My lord, any suppose, my lord, she has paid certain amount, my lord. Suppose, my lord, assessment or there are 100 rupees of demand, my lord. Whether he has paid 50 rupees as per the stay order or something like that, raised amount is, my lord, set up. Then this amount is in court and reflected in the website, my lord. Therefore, the 245 is intimation issued to the parties. That is the demand lying against you. That is practically this is happening in all cases. In my case also, I have been the similar intimation.
This is all because of artificial intelligence.
No,
that's what
it is.
Automatically, if this is the appeal has been sent back, immediately generate a computer generated kind of a thing.
That is automatic because of the
without examining the file, without seeing if there is some order of a high court, nothing.
Therefore,
mechanically just raise a demand.
That is the wording, the intimation in writing to such person action proposed to take an order. It is not a demand, Milord. It is a proposed action, Milord. Kindly, Milord, visual. It is a proposed action. It is not a demand. Therefore, he may file a reply before the authority. It may be considered.
You see, the challenge in the present petition is to an intimation dated 9th February 2023, sent to the petitioner by the Deputy Commissioner of Income Tax, Circle 1, Cuttack, in relation to the assessments made, assessment order, in relation to an reassessment order under Section 147 of Income Tax Act 1961, dated 31st March 2016, for the assessment years, bracket AYs 2008-09 to 2014-15. Paragraph. The background facts are that against the aforementioned reassessment order, the petitioner SSC filed an appeal before the Commissioner of Income Tax, bracket appeals, bracket CIT A, which came to be allowed by the CIT bracket A by the order dated 30th August 2019. Full stop. During the pendency of the above appeal before the CIT A, the petitioner SSC had approached this court with writ petition civil 5108 of 2017, which was disposed of by an order dated 27th April 2017. Lifting the attachment of the petitioner's accounts, conditional upon a fixed deposit in the sum of rupees 30 crores approximately of the petitioners with the Andhra Bank continuing to remain attached, open petition, without being remitted to the department without leave of the court. Unquote. That interim order admittedly continued during the pendency of the appeal before the CIT bracket A. Paragraph. Agreed by the order of the CIT bracket A allowing the petitioner's appeal, the department went in appeal before the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack bracket IT18, in ITA numbers 389-392 and 465-467/CTK/2019. Paragraph. The said appeals were disposed of by the IT18 by an order dated 23rd June 2022, remitting the appeals to the file of the CIT bracket A on the short ground that the assessing officer bracket AO had not been heard by the CIT bracket A before allowing the appeals of the SSC. Paragraph. The position, therefore, is that the appeals before the CIT bracket A stand revived. Full stop. These were appeals of the SSC, and therefore, when the appeals revived, the interim order passed by this court on 27th April 2017 in petition civil 5108 of 2017 also revived. Paragraph. Unmindful of the above fact of revival of the interim order, the impugned intimation has been sent on 9th February 2023 by the DCIT, requiring the petitioner to pay the single quotes balance unquote demanded amount by invoking section 245 of the Act. Paragraph. Having heard Mr. Siddharth Rai, the senior counsel of the petitioner, and Mr. T.K. Satpathy, a senior standing counsel of the department, the court is of the view that the impugned intimation was misconceived, essentially for the reason that with the revival of the assessee's appeals before the CIT bracket A, the interim order passed by this court on 27th April 2017 in Writ Petition Civil 5108 of 2017 also stood revived automatically. And there was no occasion, therefore, for the assessee to be asked to pay any balance single quotes demand unquote amount. Paragraph. For the aforementioned reasons, the intimation dated 9/2/2023 is hereby quashed. So it is clarified that during the pendency of the appeals before the CITA, the interim order passed by this court on 27th April 2017 will subsist. Full stop. The writ petition is disposed of.
Your Lordship, kindly, these honorable courts are usually confined to 14-15. That is not the whole.
6 writ petitions were filed, my lords.
To see the order.
In each of these writ petitions, while disposing of
numbers.
I'll give the numbers.
But only it is
I'll give the
only
numbers.
14 and 15.
No.
You are enclosed.
Yes.
No. You
I
are
am
enclosed.
enclosed. Yes, that's right. But I have
This is only 14 and 15.
with 14 and 15. You are the
You are not enclosed in
Yes.
other order.
Lordship, may I kindly see? I am giving all the numbers. WPC number 5108 4694 4181.
Where do you have
Page 42, my lords.
Page?
Page 42 of 2017. And Miss Case 6172,
All right.
6171.
Say, common order. You say the common order dated 27th April 2017 in writ petition civil
You are not reading the
5108 469
order.
4181.
It's not a greeting.
All right.
Yes.
Item number 4.
Much obliged. 4, my lords. I have filed the consolidated cost title, but the name of Asyan and Mittal has not been substituted. And I have also filed the resolution plan by way of an IA, my lords. That has also,
Not been listed.
yes. Lordship, may I kindly allow my
What's that number?
lords, IA number is 15279, my lords, of 2022.
15279 of
Yes.
2022. You say for the reasons stated therein, the application is allowed. The further consolidated cost title be filed within a week. List on.
Well, I'm appearing for the department. Let a copy of the IA and the consolidated petition be served on me. my lord.
I'll solve.
Copies thereof be served on counsel of the department.
By Friday, I will.
14 September.
I've entered up here. This one.
Well, that's 14th September. Oh,
Yes.
my.
Item number 5.
Item number 5 and 16 are the same. This
Yeah.
can be disposed of. If a lordship will look to the brief, serial number 5, I have enclosed the order passed in the other case. Just may I kindly come to page 45. This petitioners, I have enclosed the copy of the order which was passed in item number 16 for convenient. That is at page 48. Page 48. Third, as an interim measure, we direct that all subs of the petitioner other than on-sub at Lepripada. We are concerned with now on-sub of Lepripada. We renewed on payment of fees and shall be permitted to operate the said sub other than the Lepripada on-sub. Now, what has happened, Lord, this REIT application was listed in 2022 on 12/12/2022. That is very much there in item number 16. Somehow, your worship said that my associate had appeared on that day, very date. He said that he had no instruction. Your worship disposed of the matter, saying on prosecution dismissed. Now, the whole my prayer is they have taken a stand in the counter in that case that they will act in terms of the rules 26A. Now, this matter can be disposed. Now, in the meantime, after disposal of that writ application, the interim order lapsed. So now let them take into consideration in accordance with the rules And I have also made my representation that there is some serious protest by the Gram Panchayat and they have not obtained the permission from the Gram Panchayat. Let them consider it. That's it. My representation is annexure 9 series. Page 49. In accordance with the rules, Rule 26A, they have taken the plea in the counter that Rule 26A of the Bihar and Orissa Excise Rules 1965. And the other one, you also see that I filed the application to recall that order. So both the matter can be disposed of, item 16 and item 5.
And next,
9 series. 9 series. Page 49. Page 49. Because of the interim order that was operating till your lordship disposed of the matter on 22/12. And the subsequent, in the meantime, after that was relating to 2015-16. Now the right from 2016 till 2022.
For outstill shops, there's no new policy, is it, Mr.
No.
That is for IMFL ops.
On and off.
OS.
I am saying so, but so far the rule is concerned, they have taken that stand also in the counter. 26A of the Bihar and Orissa Excise Act 2019-15 also says that they must obtain the permission from the Gram Panchayat and all these things for the purpose of renewal.
Now shop is running condition.
No, but
it's not.
It has been stopped.
He's already having 8 outstill liquor shops in Sambalpur.
Yes.
You're already running it.
But that's right. That's right.
So this whole litigation only for the slave free part.
Yes, sir. Left report.
Okay.
privilege holder.
But so far as the interim order of 2015, permission was granted to operate
Other shops.
others.
Other than left report.
So actually the disposal of this repetition doesn't affect you.
Therefore, I have filed the writ application. The problem would be, so 102A. So if your lordship will, now this order, if your lordship will
Your
retain,
lordship may say that representation should be disposed of without taking into, notwithstanding the dismissal of the.
All right.
yeah, that's right.
All right.
In terms of 26A. That is.
All right. Just put down 5759 of 2023. The short prayer in the present writ petition is for a direction to the opposite parties to consider the petitioner's representation, bracket annexure 9, for renewal of his license for the Lefri Pada outstill liquor shop at Sundargarh district. Paragraph. Earlier, on account of the protest by the Gram Panchayat, the question of the petitioner operating the said pawn shop upon renewal of his license was kept in abeyance.
Yes.
So the petitioner had earlier filed a petition civil 5643 of 2015, in which an interim order was passed by this court on 10th April 2015, stating to the effect that all the other shops of the petitioner, other than the on shop at Lefri Pada, will continue to operate upon renewal of the license in accordance with law. Paragraph. That petition came to be dismissed by this court subsequently on 12th December 2022, when the court is informed that the counsel of the petitioner had no instructions. Paragraph. The apprehension now expressed with the petitioner is that in view of the dismissal of the earlier writ petition, civil number 5643 of 2015, the petitioner's request for renewal of his license for the Lefri Pada OS shop will also not be considered by the department. Paragraph. It is clarified that notwithstanding the dismissal of writ petition civil 5643 of 2015 by this court by order dated 12/12/2022, the petitioner's representations, bracket annexure 9 series, made to the excise department for renewal of his on shop. You say for renewal of his outstill liquor bracket on shop will be considered in accordance with law by the department. Full stop. The excise department, superintendent of excise, right?
Yes.
Yes.
The superintendent of excise will inform the petitioner of the final order passed on his representation.
Your Lordship may direct them to take order because
Yes.
31st March it will be.
Yes.
renewal is-
Allow me to take notice by special messenger or by speed post, whatever Lordship will say. I'm ready.
13th March 2023.
Your Lordship may say before considering the renewal application, his representation should
Should
be
be, yes.
taken care of.
Yes.
Because on March 31st, they will renew.
Right.
So before renewal, his representation may be considered.
Yeah. So order on the representation will be passed and communicated to him by 13th March.
Yes, ma'am.
Yes.
That is
Right.
Can I Lordship only say that so far as the section 26A is concerned?
that. They
No,
could,
let me
Superintendent will take
in
care.
accordance with rules, Your Lordship.
Petition 5759 is disposed of in the above terms. Then the other matter, you put down the IA
Yes.
number. In view of the order passed today in writ petition civil 5759 of 2023, the present application is disposed of in the same term.
Yes.
Your Lordship may say in that case, notwithstanding the dismissal, or otherwise,
You have said.
that, yes. Okay, then it's, otherwise he will
Item number
confuse.
6.
Item number 6, my lords, these are all covered by Narottam Rath's case. We have
Alright.
given it in the synopsis.
But
my lords.
this is a writ appeal, Your Lordship, that how it came to single bench, and I have to examine this.
Yes, I'll show, my lords. These orders of the ASOs are completely without jurisdiction. The ADM had allowed it at page 47. ADM's order is at page 47, where the lease was in favor of the present appellant only, it was confirmed. All this is clearly specified in the list of dates.
My Lord, Your Lordship may give me some time. I will examine the file because for the first time it is listed. It is directly, it is not writ petition, it is a writ appeal. The Honorable Single Bench has rejected his writ petition. How it is covered by that Narottam Ratha case, I have to examine it.
So in Narottam Rath, there were many orders of the Honorable Single Judge also where they had entertained and sent it back.
All right. So Mr. D.K. Manthil under AG needs time for instructions. List on. March 28th.
In the interim, let there be status quo over the case line.
What is likely to happen? I don't think it is likely to happen.
Nothing will happen.
In fact,
with-
after Narottam Rath, what they have done, they have formed a committee to sit in appeal over the orders of this court. There's a 3-member committee which is
Anyway,
looking
that
into
is
That is, that comment will do its duty.
All right.
Item number 7.
May I please, Your Lordship? The order being before my lords is under Annexure 3. Even though the appeal has been preferred, my lord, till then the appellants have remedy under subsection 3 of 12 of Orissa Prevention of Land Encroachment Act. I seek your lordship's liberty to move before the RDC in respect
Counsel
of
for the
the,
appellant seeks leave to withdraw the present writ appeal
my lord.
with liberty to, then what you'll have to
File appeal before the RDC.
RDC, my lord.
appeal
RDC
before the
Northern
Deputy
Division.
Divisional Commissioner against the
Against the orders under Annexure 8 and 9, that is at page, order of the appellate authority as well as revisional authority. Annexure 8 and Annexure 9 to the.
what did you challenge before the single judge?
My lord, the Honorable Single Judge had dismissed the writ petition. There was no whisper with regard to that provision under subsection 3 of section
So
3.
on merits, the single judge has already dealt with it.
Yes, that
You
is.
should have told the single judge you want to withdraw
This
and
should
go.
have been, represented before the
Submission should have
Honorable
been
Single
made to the
Judge.
single judge.
Withdrawal at the instance of
File a
the
review
appellant
petition,
in
make
an
that-
appellate stage.
You
It's
want
not.
to make that submission, you make it before the single judge by filing a review petition.
My lord.
Counsel, the petitioner seeks leave to withdraw the writ with liberty to file a review petition before the learned single judge, offering to avail the statutory remedy available to the petitioner according to law. Disposed of is withdrawn with liberty spread. Right.
Item number 8.
Obliged.
May I please, Your Lordship, here, Your Lordship, petitioners at the villager, they are seeking direction to the opposite party number 4 to take action against 5 to 9, 5 to 7 who have illegally encroaching the government land, Your Lordship, that is The embankment of their village
Alright.
pond.
Petitioner's representation bracket annexed
Annexed to your lordship.
will be considered by the
Opposite point
Tahsildar,
number 4.
Tahsildar Daspala, and after hearing the petitioners as well as opposite parties 5 to 7 and giving them a hearing, a reasoned order shall be passed not later than 1st May and communicate to the parties not later than 8th May. The court clarifies it is not expressed in there.
Item number 9.
Item number 9, Your Lordship, this is a public interest litigation challenging the non-implementation of Mental Health Care Act. Your Lordship, as per section 55 of the Act, which speaks about the authority, it should sit 4 times a year. But as per, from 2017, it is just sitting 3 times. And similarly, as per section 29, Your Lordship, there should be some program for implementation and creating awareness programs, which has not been implemented. I have annexed the RTIs also.
All right, the petitioner's representation, bracket section 9, shall be examined by the Director of Public Health.
Your Lordship.
No, Principal Secretary, Health and Family Welfare Department, and after notice to the petitioner and giving the petitioner a hearing, a reasoned order should be passed thereon not later than 3rd July and communicate to the party petitioner within a week thereafter. The court clarifies it is not expressed.
Deeply obliged.
Item number 10.
My lord, at flag
Item 9,
JD, your
address
lordship.
will be noted, ma'am.
At flag JD, your lordship, the consolidated question of law has been framed. Flag JD, my lord. May I read it, my lord?
Yes.
Whether the assessment order and the consequent order not liable to be invalidated, in terms of section 41(4) of the OVAT Act, the AVR was not submitted within 7 days from the completion of the audit visit, which is covered by my lord's order in the automobiles, your lordships. And the second question is whether in the fact and circumstances of the case.
First question is covered, then that's the end of the matter.
My lord.
Your Lordship has adjourned all these matters, Your Lordship.
You see, inasmuch as one of the questions raised in the present revision petition concerns the delay in submission of the audit visit report, and that issue is now pending the Supreme Court of India.
Lordship, in that order, only the date may be corrected, 18/11/2022 in place of 23. In the first paragraph of Your Lordship's order. 18/11/2020.
In SLP civil number 21607 of 2022, in which notice has been issued on 18/11/22. The present petition is adjourned sine die with liberty to parties to mention for listing after disposal of the aforementioned SLP.
Good. My lord, out of 20 lakhs, 25 lakhs of the dealer has already petitioned to 12 lakhs rupees. So I may be allowed, your lordships. Out of 25 lakhs already deposited 12 lakhs, my lords.
Then if you're adjourning sine die, then we can't have it that way. So what are the others? Are they taking any coercive steps?
Because the month of March is approaching, the revenue is running up to your lordships.
No, but has
A lot
demand been issued, any attachment been ordered? Nothing. Then you see list on, otherwise you see in view of the pendency list on 9th October 2023. Full stop. All right.
Okay.
Yeah. All right.
Item 11.
May I please, yours? I have removed the defects, but last 2 defects is not required because the grounds, I have filed the statutory form, the statutory division has been filed. Grounds is not, it is only a question of law. So that defect may be ignored.
I think this question of law has already been decided by Your Lordship. So far as that revised return 33.5.
No,
the restriction of
question of 33.5. I have paid certain amount during the course of audit proceedings. It has been found that I have paid the extra, and in the assessment itself, it has been considered. But subsequently, in the appellate forum, they could find that since it has been filed after the issuance of the audit visit, notice of the audit visit, so that amount will not be taken into consideration while computing the tax liability. If that would have been considered, my tax liability would have been lesser and penalty would have. That 9 lakh
Recently, we have added
Exactly the particular issue has already been decided, Your Lordship.
as a result of audit.
Combined
prior
reading of
to
section
amendment.
33.4 as well as 33.5, both, Your Lordship. So
33,
once
if I can be permitted to read the provision of 33, if I am disclosing the additional tax amount up to the turnover, then it is
Your Lordship, but paragraph 2 and paragraph 3, paragraph 2, Your Lordship has categorically held that once the date of revised return as per section 33.4 has been lapsed, so you are precluded to revise your return and also not to make any payment once the audit visit notice has been issued. Here, audit visit notice has been issued and he has participated in the audit. And in the audit, after that, he has paid the amount.
No, that has been found that it has been paid because that amount during the course of it has been found and it was considered in the audit assessment. That exact amount has been subsequently, they said that this amount has been paid subsequent to the audit visit notice. So that will not be considered at the time of computation of my tax liability. So 33, if I take your honor to provision 33.5.
Have you seen this order?
No.
Lakshmi Narayan Bandar.
I have not.
So you better see it.
Like,
Counsel for the department places reliance on the order dated 7/12/2022, passed by this court in STREV 9 of 2016. Bracket Messrs. Lakshmi Narayan Bandar Katak, the state of Orissa. Answering the questions raised in the present petition against the SSC. Paragraph Counsel, the SSC needs time to examine the said order and make submissions at his request list on 14 September.
Mr. Mishra, another case, perhaps we have issued notice saying that as a result of audit, that part has been omitted in 2015. So there are two stages. One is after tax audit notice is received. Thereafter, another stage comes as a result of audit. After audit report being prepared, if it deposits that amount, that also can be considered prior to assessment. That is what
Your Lordship, that can be considered to give the effect of the tax, not penalty. So penalty, so far as levy of penalty.
We have issued notice.
Your Lordship, I will examine.
Anyway,
in my case, your lordship have issued notice. If it is of assessment prior to 1/10/2015, when the amendment was carried out, that it stretches much beyond the notice of audit.
When is that coming up?
No, that was, I have to find out.
All right. Anyway, this we've kept for 14 September. All right.
Item number 12.
May I please?
Yes, please.
Here, essentially, I'm challenging the so motu revisional order laws, and there's a delay here. Because what has happened, my lord, due to wrong legal advice, my lord, against the so motu revision order of the commissioner, my lord, instead of coming to your lordships in this present appeal, an appeal was filed before the tribunal. And your lordship would get it at page 36, annexure 4. The appeal was admitted. And when the appeal was finally taken up by the tribunal, it was found out that as per section 79(7), an appeal laid to the High Court, my lords. So I'd only humbly pray your lordship may condone the delay, my lords. Because it was a wrong forum that had approached me.
What's the extent of delay?
Lord, here, my lords, after the commissioner's order, my lords, which was communicated to me.
607 days. Sir.
My lord. Here, my lords,
also during the COVID period, I think.
It was within the COVID period, and unfortunately,
although there's a delay of 607 days in filing the present appeal, the explanation offered in IA number 1 of 2023 that the petitioner was under a bona fide impression before the wrong forum. That is the tribunal, Orissa Sales Tax Tribunal. And time was lost on that count. Paragraph, having heard learned counsel for the parties, the court is satisfied that the explanation offered is a reasonable one. And accordingly, the delay in filing the appeal is hereby condoned. IA is disposed of.
In my appeal, my lords, here, my lords, the first appellate authority allowed a refund of, if your lordship would kindly turn to page 33, my lords, of 5,06,878, my lords, After, my lord, if your lordship would turn to page 32, examining all my tax invoices and my returns, my lords. So this particular matter was taken up during the COVID period. I was in a show motor proceeding, lords. I filed my show cause. So, and unfortunately, since these virtual hearings were taking place, my books of accounts, nor my returns and my invoices were examined. And the so motor proceeding, my lord, entire refund, my lord, which was granted by the First Appellate Authority, was said to be on account of non-observation or non-examination of the books of accounts as well as the returns, my lords. If I had just placed one paragraph of the First Appellate Order at page 32.
No, we'll issue notice. I think notice is not gone in the appeal, right?
It has not gone. But in the meantime, praise stay of this annexure Commissioner's order, my lords. Otherwise, my lord, now the entire demand, my lord, of this.
We'll issue notice on that also, sir.
Lord, the lordship may kindly protect me, my lord. Otherwise, I'll be in a difficulty, my lords.
No, what are they doing? I don't think they're.
No, they have already recomputed, my lord. Your lordship would see. They have already recomputed this particular demand after the.
No, but have they attached anybody's account or?
Lord, they have already, and my lord, in the month of March, fast approaching, my lord, that will not be too far, my lords.
Earlier those anxieties were there. I don't think anymore.
Not be. No, that will be not too far, my lord. I'd only beseech your lordship may protect me, my lords. Lord, it's a question of a refund, my lords. It's a question of a refund, my lord.
Anyway, you say notice, he accepts notice. Both put down the appeal as well as the IA number 1 of 2020.
No, one, unfortunately, that other IA has not been listed. One.
No, one is the stay.
One is the stay, my lord. The cause list does not show that.
No, it's here. 1 of 2020. Say notice, he accepts notice. List on 14 September. Till the next date, no coercive steps shall be taken against the petition. Appellant, against the appellant.
In person to the commissioners, so
obviously, sir.
No, this 2 of 2022 may also dispose of. That is for
the delay is controlled.
No, my lord, that 2 of 2022, my lord.
All right,
dispensing with annexes 1 and 2.
All right, that's allowed.
Obliged.
Item number 13.
Lordship, item number 13, I'm seeking a short time, Lordship, for removing the defects.
Copy also not, sir. Copy also not, sir.
So defects be removed within a week. List on 16th March.
Obliged, Lordship.
Item number 14.
May it please the Lordship. COVID. Okay.
Yes. May it please the Lordship. The Lordship, in absence of the GST tribunal,
10-20%. Same order, list on 14 September.
Item 15.
It is also 10-20.
Additionally, I'll submit, Your Lordship. I've also challenged the provision of section 16(2)(c). And Your Lordship, in the impugned order, will find at page 57 that I have paid the entire ITC. Your Lordship may have a glance at page 57.
All right. No. So what do you want is an interim order that you don't want to pay even that balance.
Your Lordship, tax demand is only 28,000 and I've already paid the 10%.
All right. There's nothing. Then you pay the entire amount.
No.
So 20%, same order. All right. 14 September.
Obliged.
All right.
Item number 17.
May I please your Lordship? OP number 5, my lord. The licensee in respect of a beer parlor, he submitted application for conversion of beer parlor to on-shop, my lord. Accordingly, there was a public notice. We filed objection. That has never been considered. Now the collector as well as the commissioner, they have
same order we are passing in so many matters.
Only second phrase, the government, let government consider before taking any final decision.
Yeah. Where is that? Similar orders must be there. There's so many similar orders we have passed. All right, the petitioner's
second trial also see. Only I have
what is that annexure?
Now his proposal is now, according to him, pending before the government.
Yeah. It is stated that the petitioner's objections, bracket, annexure 4 series, bracket, is still pending before the government. Stop. In that view of the matter, a direction is issued that the petitioner's objections will be taken into account before the collector makes a recommendation to the government in regard to the issuance of a conversion of a beer parlor into an IMFL on shop. in Mosa Bhapur for the excise year 2022-23. It's coming to an end again.
Again, 31st March, the last date. Within that, the government has to consider.
This will go on till
My lord, this is the process till 31st.
All right.
Obliged, my lord.
It is made clear that the decision will be taken in the matter only after dealing with the objections raised by the petitioners. All right.
Item number 18. May I please, madam? This is, madam, a case where petitioner has challenged the recommendation made by the Excise Commission to the government recommending setting up permitting IMF on-shop in restaurant despite of objection made by the villagers and MLA also. You also may kindly see annexure 2, initially the villagers approached the local MLA. MLA inquired, verified, made a representation by annexure 2 to the superintendent excise it has been specifically stated that so far as compliance of Rule 31 is concerned, there is no drum beat, there is no mic announcement.
No, but this decision to award the license, that is not an appealable one.
Here, no license has not been granted. Here, no recommendation has been made. By the excise.
My lord, this is the superintendent will give, collector will give recommendation to the excise commissioner.
Correct.
Then excise commissioner will send it to government. This is the process. At each says they want that their
This is not the final decision of the government. This is only a recommendation of the excise commissioner.
No. Now that this is for the excise.
So lordship may say that his objection will be taken care of by the
government. Yes. By the government, and after granting opportunity hearing
before the final order is passed by the state, it is directed that before the final order is passed by the government of Orissa in the Department of Excise on the application for on-shop license by opposite party number 5, the objections raised by the appellants to the said proposal will be taken into account and an appropriate order shall be passed.
Granting opportunity of hearing we are stakeholders.
But you have to take this order as early as possible because March is the last 31st March.
That immediately will take.
Then there's no need for hearing, sir.
Hearing is very.
The decision on the final decision be taken not later than 13th March 2023 and be communicated to all the parties, including the petitioners here. All right.
Virtually, this will become infectious barely after 2030.
What to do? All of you are coming in the last minute also.
No. Order is recommendation made on 18th, and I approached your recipient.
I know. I'm just saying the whole process seems to be
They took 4 months' time in communicating recommendation.
You are objecting to Sahu restaurant to come up.
That's only. May I make a little prayer?
The best part is that Mr. Sahu has shifted his practice to excise department. That is.
No, he is objecting to Sahu restaurant.
Oh, Sahu restaurant also. That name is Sahu restaurant.
Correct. It's in a village. The entire area will be polluted.
Villagers are more rich and they can engage senior advocates like him. Now, Mr. Ratho is feeling in
We have become insecure, my lord.
All right.
Item number 19.
Item 19 that Sarath Parida matter. 8 May.
All right.
May I make an additional request because the list is there. If your lordship take another 10 matters take on board.
Another take 10 more today. 20 per day. We'll take 20 per day.
My lord.
All right.
Item number 20.
No delays that IA is disposed of.
My lord, item number 20, my lord. In this all the cases, I appeared for the respondents, my lord. I prayed some time may be granted to file counter.
Or writ appeals, there's no need for counter. You make your arguments at the request of counsel, the respondent. List for hearing on. 21st September.
21st, man.
Yeah.
September.
September.
Item number 21.
Well, entry order may be continued, my lord, all this.
All right.
Item 21.
Good morning, sir. I appear for the appellant here. This is a writ appeal. And the single judge has interfered with the order
21.
when there is a...
So the delay of 247 days.
My lords, because there was a appeal to the Supreme Court, my lords. And the Supreme Court has given the liberty to approach the division bench. That is the reason, my lords. The Supreme Court orders is annexed in Annex 3 at page 55. And the point, my lords, is that even if there was an alternative efficacious remedy available under the statute, that was not explored, and the single judge just said that this is an abuse of process. But single judge agrees with me that there is a remedy. If your lordship see at para 11 of the impugned order, which is page 53, I'll just read one line, my lords. That is internal page 5, page 53, annexure 2. It says, it is that the petitioner can appear before the sub-collector Puri and raise the question with regard to maintainability of an appeal by filing appropriate application objection to the said appeal. But this court in exercise of power under Article 227 is not precluded from entertaining the writ petition when there is an apparent abuse of process. But my lord, there is nothing in the order which says what is an abuse of process. If your lordship see at para 6 at page 51, it is mentioned that section 42 of the settlement rules allows that there is a provision for appeal. So my contention, my lords, is that there is a efficacious remedy with the single bench also agrees, but still a judicial mind has...
All right, sir. It's only, if you want to make it time bound, we can make it time bound. The sub-collector should dispose it off within 2 months, we say, you won't be prejudiced.
Yes, my lords. But no, but now...
By the impugned order, the learned single judge has relegated the petitioner to the statutory remedy of an appeal before the sub-collector against the order dated against the initiation of proceedings in mutation appeal number 70 of 2020. Under Rule 42 of the Orissa Survey and Settlement Rules 1962. Paragraph, while the court would not like to interfere with the impugned order, since it is only one of remand, one of relegation of the appellant to the statutory remedy of an appeal, the court nevertheless directs that the sub-collector will proceed in accordance with law and after hearing parties dispose of the said appeal not later than 1st May 2023. A copy of this order be sent to the sub-collector Puri forthwith.
I'm obliged.
The writ appeal is disposed of. Right.
Item number 22. May I please your lordships? I'm for the appellant. It is a writ appeal. I filed 2 IS, one for delay condemnation of 23 days only.
All right. The delay is
order of single bench land on disposed of 5th December 22.
Delay is condoned, sir. Tell us what the matter is about.
Sir, this is a case under this LCO's local cable operator. They were working in route class steel plant since 1995. When the cable network provision has been come to play, they have been given license and we are doing the connection, giving connection to all the citizens of that RSP. So the RSP then he has entered one Ortel communication to give connection, and Ortel was also doing the same, giving same connection to different consumers. Besides this local cable TV operators. So the local cable TV operators have been licensed under the Cable Network TV 1994 Act when came. They have also been issued license to give connection. But instead of they are very small fries, and later on they floated a tender call and entered some big cable operator to the forefront. Thereby they have just lost their livelihood. And they have also, in the writ application has been filed, which has been dismissed by Lord Single Judge on the ground that it is premature. First, they have filed one writ petition and asked me to file representation before the steel plant authorities. The representation has been also rejected by the authority concerned. And later on also, the next, I filed one writ petition bearing 14,495, which were disposed of on 5th December. So my contention, my lord, is that the inclusive growth, when we are talking of inclusive growth, these people, they've been valid license holder to supply TV connection, cable TV connection networks. But by operating...
What was the prayer in your writ petition, sir? Let's see that.
Sir.
Seems to be a kind of vague prayer.
My Lord.
What was your prayer before the single judge?
To allow them to operate their connections. Give a direction to the concerned authority to include them in this cable TV network connection as per 4B provision of the Cable Network Connection 1994. My interim prayer, my Lord, they should not be, their livelihood is at stake.
No, sir, this is a policy decision, sir.
My Lord, but it affects their constitutional priority of business, proportionality of business. They have bypassed it. They have not given, they have put a condition. When they have put a condition for 7,000 poles for a cable TV network operator, 7,000 poles, they cannot enter them. So 1, 2, 3. 3 have been given tender. Big shots. They are big cable operators. So these small people, they are not able to maintain their livelihood. They were continuing till date also, my Lord. They are giving connection. No notice has been served to them. They are now disconnecting their connections. I filed one interim application, my Lord. Till then, I seek some time to argue much.
Simply say notice on stay. Returnable. 14 September. Right.
I'm not 23.
Who won? Results announced?
Yes, I lost.
You lost.
I lost by 10 votes.
Ah.
My Lord,
that person whose thing you're challenging, he won or lost?
He won.
Ah.
He won.
Now you file an election petition.
Election petition has been filed.
Ah, that's enough then. That will raise this ground.
No, the tribunal is not there. That is the predicament.
Oh.
Tribunal is not functional.
So you filed a writ petition?
No. I filed election dispute before the London Tribunal. Then since there is no available of either of the members.
No, you must have filed it yesterday only. Sir, only result was declared only on yesterday.
Yes, I challenged the nomination at the initial stage.
That is different, sir. After the result, you have to challenge the election.
The same thing will be the
whatever
ground zero.
Now that the result is known, you have a right to file the election dispute.
Election dispute.
Correct. Yeah, you can always file.
Election dispute ED number 2 of 23. This to be amended only.
We don't have to give you advice. You are such a learned counsel. You know what to do. So no problem, sir.
But what I pray, the issue is whether his nomination can at all be accepted.
All that you argue in that, sir. He's a counsel for the petitioner now. Now that the results have been declared and the appellant has lost by 10 votes.
By 10 votes.
To opposite party number 2.
Yes.
Respondent number 2.
Yes.
Counsel for the appellant seeks leave to withdraw the present writ appeal with liberty to urge all the points urged both before the learned single judge and in this appeal in the further proceedings to be which would ensue as a result of the above development. Disposed of is withdrawn with liberty is prayed for. All right.
But again, I will be back to square one. My appearance for again I have to come back to your lordships.
Correct.
My appearance for respondent 5. The impugn order was not there. I filed an application.
That application you allow first.
Yes.
All right.
I'm for the respondent 2.
All right.
The impugn order I have enclosed.
All right.
Item number 24.
Your visit to the schools and all that.
I have visited, I have submitted the report.
Okay.
Lordship would kindly see.
Yes. Have you given a copy to Mr. Mahapatra?
Yes, I have seen the reports and the photographs.
Now you have to tell us how soon you will repair all that.
Correct.
That's the only submission you have to make. No other submission.
My Lord, the reports as it reveals, it requires...
Start school by school.
Yes.
Pick up the worst. I think you can point out which that requires immediate attention.
Kindly see, page 35.
35.
This is a kind of primary school. Lordship will be surprised. 5 classes are running in one hall. One hall, 5 classes. All the students, almost all the school
students are sitting on floor, and condition of the toilet and washroom, your lordship see, it is precarious, my lord. Kindly see page 39 of my report, ma'am. Flag X. But they will have to focus on this. Kindly see page 39.
How are they supposed to be even educated like this? Really, it seems very pathetic conditions.
Page 39, lordship, got it?
1 minute, just.
Pen drive also.
Gulgulab
Padar Primary School. Look at page 39, my lord.
Right. Which district is this, sir?
This is in the district of Bodh, my lord.
All right.
And your lordship, kindly see, Lord, I have given in details. Kindly see the sanitation part of this.
Yes, it's pathetic, sir.
It's really pathetic.
Pathetic.
Every school. And one more interesting, your lordship will find.
Yes.
Students are reading on veranda, page 44, your lordship may kindly see. On veranda of the hall.
Correct.
They are not even having classrooms for the students.
My goodness.
What to talk about, my lord, there is no sweeper.
So how can we not find resources for this? This is something unbelievable.
May I pay your lordship that
sir, we'll give
some
you
time, maybe.
That's what. We'll give you 1 month's time.
Yes.
This school, what is required in the school? Let us tell.
Yes, Lord.
Page 10, my lord, the amicus curiae, what he has suggested for it, I will see that it will be taken care of. Page 10, paragraph.
But how many such schools are there? You tell us, give us a cluster of schools so that all that can be done in 1 month's time.
In fact, I was just going to request, let them file an affidavit today, present position, because they have closed down some of the schools.
Oh, I see.
Because of a notification with regard to distance and others, they have closed down the schools. And the problem now is the student people. The people, in fact, those who are reading in those schools now are deprived of primary education. They are no more attending primary schools. They are not.
No, but this Bodh school is still there.
Yes, these are the schools there.
So let's. How many schools photographs you given?
Page 3, your lordship will find the details of the school have been published.
I have given details of the schools I have visited. In fact, these are
schools and 4 upper primary schools.
I have only taken some sample schools.
That's right. 7 sample schools you have given.
Yes.
So let us start with the 7.
Yes, Lord.
Yes. In this 7, and they are distributed over several districts.
Yes.
No. So
no, this is of both district, my lord.
This is only Bodh.
All of these are of both.
Oh, I see.
And I have also planned. I have intimated my land friend.
Oh.
Next week, sometime in March, I am planning to visit that Gajpati district, my lord.
All right.
I have come across.
You have a district education officer. You have.
Yes.
Every district has a separate education officer.
Yes.
And you have a budget district-wise.
Yes, madam.
See, the budget has just been voted upon, correct?
Madam.
And there must be an allocation for education, right?
Madam.
So you can't now plead no lack of funds. This is the best month to do it now.
Madam.
So straight away start.
Not one just request, madam. Let the government file an affidavit. As on today, the number of primary schools, number of teachers there, number of students reading, because the dropout and students deprived of education will have to also address there.
No, we are only on the infrastructure part, right?
So let us proceed with the infrastructure first, then
we'll come to the.
That's fine. That's
You see, the report is perused. The report dated 22nd February 2023, submitted by Shri Prafulla Kumar Ratha, London amicus curiae, who has visited 7 schools in Bodh district, of which 4 are upper primary schools, located in the taluks. Is it Marjakud is the taluk?
Marjakud is a EP school, my lord, inside both NS6.
What is it? Is it a taluk or is it a village?
This is a village, my lord. This is
in the villages of Marjakud, Khairamal, Yuli, and Davamunda, and the primary schools at Gulgula, Junani, and Rugudipari. Full stop. Copy of the report is available It has been already provided to Mr. Mahapatra, learned standing counsel for the School and Mass Education Department. Paragraph. The photographs attached to the report depict a dismal picture of the infrastructure, if it at all can be called that, in these 7 schools. Stop. Basic amenities like portable drinking water, bench and desks, separate functional toilets for boys and girls, electricity, provision of electricity, availability of playground are starkly missing. Full stop. This is apart from the fact of lack of adequate teachers and drop in the enrollment rate of students. Full stop. In Marjakot upper primary schools, classes 3 and 4 were sharing one classroom. Full stop. The situation in the Kairamal UP school was equally pathetic. There is one teacher for classes 4 and 5. Classes 2 and 3 were sharing one classroom. And there is no bench or desk provided to students of classes 4 and 5 who were sitting in one classroom opposite to each other. I mean, this is all unbelievable.
That's what it is, bro.
4 is on one side of the classroom, 5 is on the other side of the classroom.
I was surprised in one hall, 5 classes opposing each other and one teacher. One teacher for 5 classes in one hall.
Where is that?
That is what that Gulgula Padar school.
So the situation in the Gulgula Padar primary school was, to say the least, shocking. Stop. All the students from classes 1 to 5 were sharing one classroom. Students were sitting on the open floor. One bulb was available in the entire hall. There was no office room for the school. Stop. No toilet, no drinking water facility, no playground. Full stop. No bench and desk provided in the classroom. Full stop. Students were using the open space for attending calls of nature. Full stop. There was no portable drinking water facility in the school. Paragraph. This court does not propose to add all the details provided in the report, which is now available with the state government, in the expectation that the Secretary SNME department will immediately peruse the said report, which is only a representative sample of 7 schools in Bauth district. So the Secretary will immediately convene a meeting of the collector, Bauth, the district education officer, Bauth, and ensure that funds are immediately released for the repair, upgrade, and upkeep of all the above 7 schools and any other schools in Bauth district.
Yes.
Which may require immediate attention. Full stop. In the 7 schools that have been pointed out by the learned amicus curiae, steps should be taken immediately, considering that this is the months of March and April, which is towards the close of the year. These schools must be closed now, no? In March, they normally close.
After March, it will be closed.
Consider that the school is likely to go for a summer vacation in the month of April, to ensure that before they reopen on.
That will be, I think, 20th of June.
20th June.
Yes.
All right. Before they reopen, all the repairs to all the schools are carried out. Full stop. The basic minimum facilities should be made available in each of the schools. That is electric power supply, provisions of light and fan, separate toilets for boys and girls, full stop, basic drinking water, portable drinking water facility, separate classrooms for each class, bench and desk for each of the students, proper usable blackboards, fans, lighting, and other basic comforts apart from playground facilities. Full stop. The court would like the court directs the secretary to properly instruct the district education officers to send him periodic reports on a weekly basis with photographs about the actual repair public upgradation work undertaken in each of the schools. Full stop. This entire exercise must be tightly monitored, and a comprehensive report should be submitted to this court with photographs before the next date. Full stop. The court proposes to take up the exercise district-wise. Full stop. Meanwhile, the Secretary SNME department will, on his own, or is it a woman? Who is the secretary?
Woman.
On her own. What is her name, please?
S. Awasthi.
S. Awasthi.
S must have some. Srimati S. Awasthi.
Yes.
To herself undertake the exercise of calling for reports from each of the district education officers, enclosing photographs of the actual condition of the schools, whether they are primary schools or upper primary schools or secondary schools.
No, it's primary and upper primary.
All right, upper primary schools. And indicate in each of those reports the availability of all the facilities noted above as a checklist. Full stop. Without waiting for further orders from the court, a detailed plan of action will be drawn up by Srimati Awasthi of the time period within which the repairs and upgrade of all these schools will be undertaken. Full stop. When the next academic year begins, these schools must have all the schools, all the UP and primary schools in Odisha must have most of the basic facilities that has been highlighted in this order. Full stop. This exercise has to be taken on a war footing. Full stop. The court is conscious that in the recent budget that has been passed, monies must have been allocated for this very purpose, and it is essential that it is used for that purpose at the earliest possible time, so that the benefit reaches all the school children studying in these various schools. Paragraph. In the next phase of this matter, the court would take up the issue of adequacy of staff, and of enrollment of students. That's full stop. A copy of this order shall be sent forthwith to the Secretary, School and Mass. She's the secretary or principal secretary?
Commissioner cum secretary.
Commissioner Secretary, School and Mass Education Department, for her immediate action.
Her name, your lordship, may indicate that Aswati S. Aswati S.
All right, Srimati Aswati S.
Aswati.
Aswati S. All right. Aswati is a star. Must be the star. 27. Anyway, all right. List on. We'll have it a day in April end.
Yes.
So that we know the progress.
Yes.
27th April. 27th April at 2 p.m.
2 p.m. Great.
75 was Gulgula Padar.
Gulgula Padar.
Established in 1958.
58, my lord. That's the reason I have taken the photograph of that.
Mr. Mahapatra, it should not be that only Baud gets good schools now. Then it will be discrimination against all other.
No, I got understood your lordship's
Please,
order.
you hold a meeting with her.
Yes.
And
I'm also trying to take all the district education officers a joint meeting so that it will be done and substantial progress report will be submitted on 27th April. I hope that.
And tell them that the High Court will not spare them.
Yes, madam.
So all that is lack of supervision.
That's all. That's all.
And
or lack of caring, sir. If they really seriously care, it won't happen like this.
In fact, I would like to request your lordship to add one word, functional toilets. Otherwise,
yeah. Functional toilets because water facility.
Yes.
You're right. Absolutely right.
Yes.
Absolutely right.
Absolutely.
All right.
Grateful.
All right. Thank you, Mr. Ratta.
Grateful.
My lord, may I be pardoned, my lord. In that election matter, your lordship may indicate that the fresh election dispute will be adjudicated without being influenced by the impugned order. Otherwise, those findings will be staring at me.
What finding? There are no findings there. The judges simply said you wait for the election to be over. There are no findings there.
Finding is that his nomination was held to be valid.
There are no findings there. There are no findings.
All right.
Item 25.
Yes, sir.
Exactly. There's no observation.
Notwithstanding the judgment, my lord, your lords may say, the judgment which is challenged, that without being influenced.
So there's nothing in that judgment, sir. There's nothing in that.
Yes.
Item number 25.
May please your lordship. With the case, your lordship, with my outset, your lordship, I am submitting here that they, despite after this lot of years passed to our independence, my lord, still yet in Odisha, there is a bad practice, untouchability is following of my lord. It has happened in this district of Puri, your lordship, and in 2018, my lord. Then the complaint filed before the collector, my lord, and this writ petition is filed before this court, my lord.
I think we passed an order last time.
Your lordship, short for my affidavit.
He has filed an affidavit. He has filed an affidavit, and he has also annexed certain photographs, and he has also annexed a representation which he has made to the collector and SP of Puri. My lord, what I beg to suggest, my lords, this is a serious issue. He is alleging that due to untouchability, the villagers are not allowing them to stay. The lordship may direct the district social welfare officer. He will look into the matter personally and
submit a report.
Submit a report or.
All right. An affidavit dated 17th February 2023 has been filed by the petitioner. Stating inter alia that three families in Nogam village under Brahmagiri Tehsil, Puri district are being exploited and are being compelled to live in cyclone shelters as a result of the practice of untouchability. Stop. The details of the said families and the copies of the representations made to the authorities have been enclosed. These representations are stated to be pending for over 3 years now. Full stop. To add to their woes, the victim families are stated to have been driven out even from the cyclone shelter on account of the COVID-19. Paragraph. The court directs the District Social Welfare Officer Puri to immediately visit the families at the addresses to be provided by counsel for the petitioner. Meet the authorities in question and submit a detailed report to this court before the next date. Full stop. The DWSO will also suggest the corrective action to be taken.
DSW.
DSWO, correct. DSWO. Full stop. A copy of the order should also be sent to the Collector Puri as well as the Superintendent of Police Puri to extend all cooperation and assistance to this DSWO to carry out the orders of this court. Full stop. Wherever corrective action is needed to be taken, the Collector and SP will ensure that it is so taken without waiting for further orders. Full stop. The machinery of law should be put in motion if the inquiry reveals that untouchability was in fact practiced against the victim families. Full stop. A copy of this order be sent forthwith to the Collector,
Yes,
SP,
Collector and District Social.
as well as the DSW. DSW.
DSWO Puri.
Puri. List on. April.
Item 26.
Lordship, item number 26 to 33. Lordship, item number 26, 33. Your Lordship, I may be permitted to file counter. Your Lordship, some time may be granted.
All right.
Fast appeal order.
Time for filing replies is extended by 8 weeks. Rejoinder for the next date. Interim order to continue.
My name will be appear in the cause list.
List on 21st September.
My name came.
Yeah, 21st September. The name of Mr. Chimanka be indicated in the cause list. Yes.
26 to 30.
35.
33 year.
31.
Up to
All
31.
right. 33.
Item number 34.
May I please, your Lordship? Lordship, this is a matter relating to 148 millers. It is a covered matter millers, Kailaskedia. Kailaskedia. But Lordships, in Kailaskedia cases, millers, whatever the order, I am obliged millers. But in Kailaskedia cases, millers, assessment year 13-14 was not there. So Lordship, under the unamended provisions of the Act, Lordship, my Lordship is well aware of that 13-14, 6 years millers on 31st March 2020. But Lordship, as per provision to amended provisions of the Act, Lords, if the notice cannot be issued under the old provisions of the Act, your Lordships, the same cannot be reopened under the new provisions.
Point it out in your.
Yes, your Lordship.
You will raise all the grounds there.
Correct.
Lordship already held.
Yeah.
Yes.
Same order. Be passed. Yeah. Same order.
Lordship, 34 and 35.
34, 35. Same order.
Item 36.
Your Lordship, in this matter, no counter has been filed.
Counter has already been filed. Copy shop.
Only in one matter. No?
So one matter, subsequent, second matter is not.
Counter file, we have OP number 1.
Yes, not. I have filed.
You have to serve a copy then on.
Yes, copy is on.
Only in writ petition number 25,422.
Yeah.
Second one is not, the so-called notice in challenge. You'll also only tag up that matter.
Correct.
In that case, your Lordship may fix the matter on some other date. Interim order to continue, Your Lordship.
All right. Rejoinder will be filed for the next date. Interim order to continue. List on 21st September.
Item number 37.
Your Lordship, pardon, Your Lordship. What's the date, Your Lordship?
21st September.
Highly obliged, Lordship.
Item 37.
May it please your lordships. Your lordships, in this matter, I have received the counter today itself. So this matter may be fixed on a short date for hearing.
File before the next date. There's an interim order.
Yes, your lordships.
Interim order to continue 21st September.
Highly obliged, your lordship.
Item 38.
May I please, your lordship? Your lordship, I received the counter just 2 days before.
All right, same
Your
order.
lordship, the read petition can be disposed of. Here, your lordship, I have filed the counter. Here, your lordship, without going into the counter also. Here, the attachment notice has been challenged, your lordship, and the attachment has been done after confirmation of the first appeal order. Your lordship, first appeal order. Here, your lordship, what the petitioner will challenge the first appeal order. And your lordship admitting every day 10-20%, 10% at the time of first appeal and 20%.
Appeal period has not yet been expired. Kindly have a glance to the CBI's notification because they have withhold because the 3 months the statute requires to file the second appeal is before the tribunal is 3 months from the date of communication of the order. And subsequently, CBI has already clarified that this due date of filing appeal has been extended till the president assumes this tribunal enters into the tribunal. So my due date of filing appeal is still open, your lordship.
All right.
I will be filing rejoinder, your lordship.
Rejoinder we file before the next date, 21st September. Interim order to continue.
Obliged.
Item 39.
Counter not filed.
It's not filed. In this matter, lordship, we have yesterday received the counter.
All right. Rejoinder we file before the next date. Interim order to continue. 21st.
That's right. Highly obliged, lordship.
Item number 40.
Item 40 matter, a similar matter has been fixed to 12th September.
All right. List on 12th September.
Item 41.
Interim order to continue.
Interim order to continue. All right.
My lord, in this case, your lordship, appellant 1 died and your lordship have substituted the LRs of the appellant number 1. Already that substitution have been carried out and I have filed consolidated memo of writ appeal. That may be accepted and also the notice may be issued to those LRs.
Tell us what the writ appeal is about, sir. Show us the interim order, the impugned order, sir.
No, the interim order,
no, the impugned order, sorry.
Impugned order, your lordship.
Which page?
Single judge order, your lordship. Page. Second hand. Memo को page. Memo को page.
I think there is no
227, no writ appeal is maintainable. It's a 227 order, sir. No writ appeal is maintainable. Just see the last paragraph. Come to the last paragraph.
My lord, that is the sole question your lordship on which your lordship admitted it, that the daughters became the absolute honor and also...
Come to para 13.
Look.
Impugned order para 13. Which is that full bench order on maintainability of writ appeal? I'd asked you to keep the judgment.
I'll come.
Mr. Ishwar Mahanti, that day Muhammad Saud case you have got 2010 some SEC reference.
Come to para 13 of the impugned order, sir. Just give me the hard copy. He's hunting all over the place. Just showing the impugned order, para 13.
This is against the commissioner's order. You naturally 227 is invoked.
Order is under Article 227.
That is quite obvious because against the order of the commissioner.
Yes, sir, lordship. Against the order of the commissioner, both the
So kindly read what we have flagged up.
This
is your own paper book. Please take it from him, sir.
No,
no, you may still be hunting. He has straight away got it for you. Otherwise, you will be unnecessary wasting time hunting. We want to make it easy for you.
Considering the
last 3 line.
No, it's okay. Let him read the whole paragraph. Considering the matter.
From any angle, this court finds that the Commission of Consolidation has taken all the facts and the provisions of law into consideration, and the conclusions arrived at by him are neither perverse nor erroneous, neither fell on the ancestor of the petitioners, nor the petitioners themselves have taken any steps all these years to assail the decree passed in title suit. In other words, what they did not do directly cannot be permitted to do indirectly. When a remedy was available to them, they ought to have availed for the same, as it would be impermissible to avoid a decree passed by a competent civil court in a proceeding under the Consolidation Act. That apart, this your lordship.
That please kindly read, sir. This is the most important sentence.
That upper jurisdiction of this court under Article 227 of the Constitution of India, being discretionary in nature, this court is not inclined to interfere with the impundition of the commissioner. Even otherwise.
So this is an order passed under Article 227 of the Constitution.
Yes, Lord.
Now we'll give you a copy of a full bench because you may not have had time to do the research. So we have done it for you. We are giving you a copy of the full bench decision of this court.
Lord.
Kindly see that.
Yes, Lord. I've gone through it. Yes, Lord. I have gone through this.
Very good, sir. Then it makes it much easier for us. All right. The impugned order of the learned single judge, which dismissed the writ petition filed by the petitioners against the order of the Commissioner of Consolidation, was under Article 227 of the Constitution of India. The last paragraph of the impugned order very clearly mentions this fact. Full stop. Paragraph. That being the position, in view of the position of the full bench of this court in Mohammed Saud versus Dr. Major Sheikh Mahfuz, 2008 2 OLR bracket FB 725, which has been affirmed by the Supreme Court of India in Mohammed Saud versus Dr. Major Sheikh Mahfuz, 2010 13 SEC 517. The present writ appeal is not maintainable and is accordingly dismissed. The interim order is vacated. This will not prevent the petitioners from appellants from seeking appropriate remedies in accordance with law.
Your Lordship, already fact info is over.
All the writs.
Item 42.
May I please, Your Lordship? I'm appearing through VC, my lord. The appellant has challenged the order of the Honorable Single Judge direction, where the direction has been given that the appellant to consider the period of service rendered by the respondent number 1 for pension by condoning the deficit of 9 days of service and recalculate the pension. The fact of the case is that the respondent number 1 was initially engaged under work charge establishment in 1/8/1964, and he was brought under regular.
What is the age of respondent number 1 now?
80.
How old is he?
Must
80 years, man.
He's almost 80 years. We'll make it peculiar to the facts of the case and say that it will not constitute a precedent. You see, the delay is condoned.
There is a strict rule, my lord, where there is a strict rule. My lordship may see Annexure 213 and also Rule 18(3) of the Odisha Pension Rule, where he has not worked for 5 years continuously.
Yes.
He will not be given the pension. He will not be considered under pension.
All right. He fell short. What was the shortfall? 9 days. All right.
Yes, my lord.
All right. The shortfall for the qualifying service for the purposes of pension was just 9 days. Full stop. The respondent number 1 is already more than 80 years old now. Full stop. Keeping in view all these facts, the court is not inclined to interfere with the impugned order of the learned single judge. Full stop. It is nevertheless clarified that it will be treated as having been passed in the peculiar facts and circumstances of the case and will not constitute a precedent. The writ appeal is disposed of in the above terms. All right.
Item 43.
I am for the appellant. The respondent, I don't know, they are passed over. It is in some other court. Prepared for him to come. I pray for passport for his behalf. I am for the appellant, bro. If my permits. Because in the morning with me, he has gone to some other court, Mr. Patnaik's junior. But here in this case, there was a plywood factory in Odisha established by the government that went sick. Established in 88, in 92 they become sick. It was closed. Then they transferred that factory to the Odisha Forest Development Corporation in 91. And the staff of the factory, there was a marketing manager come liaison officer to deal with the sale of the finished product, plywood. But once factory is closed, he has no job. And that factory came to us in 91. And till 97, the factory could not run. In 97, we gave it on lease to...
The man has died.
Man has died. He retired in 2010 itself.
Sorry?
He reached superannuation in 2010. In 2015, my single judge says reinstate him.
That's okay. At least he'll get his back wages. When was he dismissed?
He has not back on, Malad.
When was he dismissed?
He was dismissed in
2000.
2000.
And the impugned order, when did he retire? The superannuation age was when?
2010.
For 10 years.
10
what is the amount working out to?
No, Malad, this only single judge has directed, when see the order, single judge. The order is to reinstate.
No. The main part is that other part, sir. Reinstate with back wages, no?
No, not back wages. So, direct to reinstate the petitioner service with all consequential benefits.
Consequential benefit means as if he's even service.
Malad.
So what will you pay him? Nothing. No back wages also.
Malad, what is
you have a pension scheme or not?
Malad, no.
You don't have pension scheme. Why are you in appeal then?
Malad.
Why are you in appeal?
Malad, what I say, the term of the appointment, Malad, see,
why are you in appeal?
Because, Malad,
what will happen? Suppose there is no appeal, what will you do?
Yes, that is legal, sir, on record, Malad.
What will you do, sir? Under the impugned order, what will you do? Tell me.
I cannot reinstate him.
What will you do?
Dead.
What will you do?
Unless they claim something, I cannot do anything, Malad.
So you don't even know why you are aggrieved. Simply, you have to file an appeal. Somebody told you, sir, appeal, you have to file appeal. So you filed appeal.
Malad, see, only for a moment.
You also got notice and stay, which is remarkable. Tell me, what do you have to do under the impugned order, sir? Tell me.
I am only that he may claim back wages, that I am before this.
What is that back wages?
That nobody has calculated as yet.
Nobody calculated. He also didn't calculate. You also didn't calculate. But you have to still file an appeal. And drag them. Now they have engaged a lawyer. They've paid his fees because of your great magnanimity.
Only one moment.
And you're wasting the time of the High Court also. You know fully well you have nothing to do. Even if you dismiss this appeal, nothing, you have to do nothing.
That's right.
Is this not abuse of process of law, sir? And dragging one whole family of a deceased person.
Like they have come forward.
They have come because you extended an invitation. You asked us to go and invite them. So at your behest, we have invited them.
They filed a petition to that he has died. Two parties. That is we have invited parties. Well, one question.
No. What is the cost, sir? How much have they spent on this litigation so far? How much have they spent? At least 50,000 rupees. At least. No, you first deposit that 50,000 before we proceed. There has to be a full stop to these things. Total waste of High Court's time, total waste of 3 people's times.
No, when
you have no grievance. You have no, man is dead. You know fully well you don't have to comply with the order.
After irritably he died. He died after
you know fully well now you don't have anything to comply with. The day you are told he's dead, you know that you don't have to comply with, but you will still persist with the writ appeal. Correct?
They have conferred to be parties.
Sir, you are the appellant, not that they have come forward. You are the appellant. And you have implemented them. We can see the cost title here.
Because of their approach, they have.
You first deposit costs. You said, despite fully knowing that the impugned order is incapable of being implemented, with the original writ petitioner having expired in 2010 itself.
No, 18, 16 he expired.
In 2016 itself. The appellants have persisted on pursuing the present appeal with the legal representatives of the original writ petitioner having been made parties and having already spent considerable amount in defending their present writ appeal. Paragraph, when asked what was the precise grievance, counsel of the appellant states that they apprehend that back wages may be claimed without even having quantified what those back wages are. Full stop. The court considers this writ appeal to be a sheer abuse of the process of law. Full stop. Since the appellant is insisting on continuing the pursuit of the present appeal, the appellant will deposit in this court a sum of rupees 50,000 by way of a demand draft in favor of the respondents. Respondent number 1, who happens to be the widow
it is a government
of the deceased employee.
It is a government corporation, not a loss.
This order will be complied with on or before 13th March 2023.
It is a government corporation.
List on 14th March. If this order is not complied with, the divisional manager, Orissa Forest Development Corporation Limited, will remain present in virtual mode. List on 14th March.
Kindly excuse me, Lord, that item 44 will be much high.
A copy of this order be sent to the managing director of the Orissa Forest Development Corporation forthwith for compliance. Yes.
I will explain item 44.
Yes.
Kindly recall that. I will withdraw the writ appeal. I will withdraw the writ appeal. Sorry. Kindly allow me.
All right. He's a counsel for the learned senior counsel for the appellant seeks leave to withdraw the present appeal. Dismiss this withdrawal. All right. All right. Yes.
Item 44.
But if I can request your lordship, give me a week time to examine this. Just, but I request your lordship, give me a week time to examine the matter.
All right. At the request of Mr. Rath.
Sometime in April, Lord.
No, what's the urgency? There's no urgency in these kind of matters. 21st September. All right.
Item number 45.
Item 45, my lord. This is similar to item 20, my lord. 20 was fixed on 21st September, my lord.
All right. Just on 21st September.
For the appellants, my lord.
All right.
Item 46.
Well, 46, I am appearing for the respondent.
I am for the appellant, By the impugned order, the Honorable Single Judge has been pleased to allow the writ petition at the stage of admission, even without issuing notice to this appellant.
We'll send it back, sir.
Yes, my lord. It's already covered. My lord has already decided.
You offer the respondent?
Yes, sir.
The impugned order was passed on the very first day without even notice being issued to the present appellant. On that short ground, it's set aside. And writ petition civil 14036 of 2021 is restored to the file of the learned single judge in the roster bench, where it will be listed for directions. On 8 May 2023, the appellant will file a reply to the writ petition on or before 24th April 2023, and rejoinder thereto will be filed by the writ petitioner by 8 May 2023. No further time will be granted for the purpose. The learned single judge is requested to proceed with the hearing of the writ petition on merits and endeavor to dispose it of as expeditiously as possible.
Item 50 also similar.
Item
55-0.
You are there in 50.
I'm appearing for respondent number 1. My lord,
In
the
50.
copy has not been served on me.
On 5 in 50.
Yes, my lord.
He'll serve the same order in same 50. All right.
Item number 47.
May please. 47. Mr. Kunal Kumar Sai has appeared in person to notice.
Same.
First day. And also that Sartapada matter, your lordship has fixed to 8th May. Some cases, their notice has been issued. And in this case, on the first day, the matter has been disposed of.
Same one. Just put down the name of that consular. You are there.
Appearing for respondent, my lord.
Same order. Both matters.
Yes, ma'am.
Item 48.
48, your lordship has posted the identical matter to 14th September 2023.
Read appeal number 432 of 2022.
This is that all right. All right. 14 September.
Item 49.
In item 49, I'm from the respondent. I need a very short adjournment. Mr. Senapati, who is briefing me, his wife has been hospitalized since yesterday evening.
Mr.
Interim order, they are in favor of the plan.
Mr. Manoj Mistral and Senior Counsel. I request Mr. Manoj Mistral and Senior Counsel appearing for the respondent list on 14 September. Sir, 21st September. Sorry, 21st September.
Sir.